In this video, we're going to talk about why the DOJ, Department of Justice, just flipped on the Second Amendment. Imagine the federal government, long seen as hostile towards gun rights, stepping into the courtroom for gun owners. That shift is happening now. In this video, we'll show you why the DOJ just flipped its posture on the Second Amendment and what it means for your rights. Before we dive into the DOJ pivot, we need to understand the legal foundations. In the District of Columbia versus Heller, a 2008 case, the Supreme Court affirmed that the Second Amendment protects an individual right to own a firearm for self-defense, not just a militia right. McDonald versus Chicago, a 2010 case, applied that right to the states through the 14th Amendment. But the real fundamental shift in doctrine came from the New York State Rifle and Pistol Association versus Bruen in June of 2022, otherwise known as the Bruen decision. Courts must ask, number one, does the challenge regulation fall within the text of the Second Amendment? If yes, two, is it consistent with this nation's historical tradition of firearm regulation? That two-step framework is now the default for all federal and state gun litigation. Since Bruen, courts have grappled with how to apply historical analogs, balancing modern regulation with constitutional constraints. United States versus Rahimi, a 2024 case, sharpened the analysis. It upheld federal prohibition on firearms in domestic violence restraining order situations, but it emphasized that any restriction must be analogized to the historical tradition of disarming dangerous individuals. I'm Steve from Martell Training Group, retired New Jersey State Trooper, former paramedic, firearms instructor, and author of Defend Confidently. Today we're going to look at DOJ's shift or flip on Second Amendment cases. In early 2025, under Attorney General Pamela Bondi, the Department of Justice began signaling a recalibration. DOJ announced a Second Amendment task force intended to coordinate litigation, policy, and enforcement in favor of gun rights. DOJ's budget requests include funding for a firearms rights restoration initiative within the Pardon Attorney's Office, enabling it to hand Title 18 925C petitions. DOJ has publicly committed to prosecuting and suing local jurisdictions that unreasonably delay carry permit processing. Previously dormant regulatory and settlement mechanisms, for example trigger devices, are being reconsidered. These aren't rhetorical shifts, they are legal commitments. The question is, will DOJ live up to them in the courts? Let's look at how these shifts are emerging in real lawsuits and rulings. DOJ versus Los Angeles for CCW delays. One of the most dramatic manifestations is DOJ's pattern or practice investigation of the Los Angeles County Sheriff's Department over concealed carry permit delays. Average processing times reportedly reached 281 days. Some applicants waited over 2 years. DOJ's theory? Excessive delay itself violates the Second Amendment because a right delayed is a right denied. The DOJ alleges that these delays are a deliberate tactic to obstruct Second Amendment rights, while the LA Sheriff's Department cites understaffing and a backlog. If DOJ wins, it would set precedent. Local governments must act on carry applications promptly or face federal enforcement. I know people in New Jersey, where I'm from, are feeling this as well. Some have waited months for their carry permits. Firearm rights restoration. For decades, Title 18 U.S.C. 925C allowed individuals prohibited from possessing firearms to petition for relief, but the relief mechanism was never meaningfully implemented by DOJ. It was effectively dormant. In 2025, DOJ proposed a new rule to operationalize 925C, establishing criteria for application, standards of review, and disqualification. So for example, violent offenders or for people convicted of sex crimes would not be eligible. This change gives formerly disqualified individuals a regulated path to reclaim their firearm rights. But DOJ's exercise of discretion, in other words, denials, delays, criteria, thresholds, will likely be litigated as well. That means DOJ is not just defending current rights, it's offering a route to restore rights previously lost by certain individuals. Rare breed triggers settlement. Another pivot, DOJ's settlement with rare breed triggers. Prior ATF interpretation had classified certain force reset trigger devices as machine gun conversions. Under the settlement, in which both parties agreed on certain conditions moving forward, the federal government agreed not to pursue enforcement actions on these devices and to return seized property. This rollback underscores DOJ's willingness to reevaluate and reverse prior restrictive positions, especially where enforcement overreach has been contested. USPS handgun mailing lawsuit. We now have a fresh pro-rights lawsuit targeting the federal postal ban on mailing handguns. In July 2025, Gun Owners of America, Gun Owners Foundation, and a private plaintiff filed Treb versus U.S. Postal Service in U.S. District Court, Western District of Pennsylvania. The plaintiffs challenged Title 18 U.S.C. 1715, a nearly century-old statute that prohibits private individuals from sending pistols and other concealable firearms through the mail. Congress allows government and FFLs to mail them, but forbids lawful citizens from doing so. They argue this ban lacks historical analogs and thus fails Bruin's second step. The complaint requests that the court declare the law unconstitutional and enjoin its enforcement. This lawsuit pushes the boundary. It's not about carrier possession, but the method of legal transfer. A frontier regulation that DOJ might be compelled to support if it's serious about pro-rights posture. California's ammunition background check law is overturned. In late July 2025, the Ninth Circuit held California's law requiring background checks for ammunition, which was passed in 2016, unconstitutional. The court agreed with the district court that the law meaningfully constrains use of firearms, and California failed to show historical analogs. The court emphasized the right to keep and bear arms includes the right to operate them, which requires ammunition. This ruling reinforces that regulation of ammunition cannot be separated from regulation of the firearm itself. If DOJ supports or intervenes in similar state challenges, it widens its footprint beyond just carry and device regulation. California one gun a month law. Now New Jersey has a similar law. In Nguyen versus Bonta, the Ninth Circuit invalidated California's one gun per 30 days law as fundamentally unconstitutional. In other words, it's invalidated all possible applications, not just a specific instance. The court found that the regulation placed a meaningful constraint on the ability to acquire firearms and that California failed to present a historical equivalent. New Jersey has the same law that restricts you from purchasing more than one handgun in a 30-day period. It's crazy because in New Jersey you can buy as many long guns as you want in a 30-day period, shotguns or rifles, but you can only buy one handgun every 30 days unless you meet certain exemptions. This is a powerful precedent against laws that ration firearm acquisition, and one that DOJ, if active, could support in appellate or amicus roles. Let's talk about why these cases matter beyond the headlines. Number one, text plus history as the battleground. The Bruin framework anchors all new gun litigation. DOJ's participation in these suits signals which arguments it will lend weight to. Strict historical analogs, narrow tailoring, and text-based reasoning. Number two, delay equals denial. If carrying delay cases succeed, governments must process permits promptly or face Second Amendment liability. Police departments need to hire more people to process these applications. That's what it comes down to. Number 3, discretion and restoration. The Title 18 925C process will be legally tested. How DOJ exercises discretion, sets criteria, and denies petitions may face arbitrary and capricious challenges. Number 4, accessory and transfer regulations are vulnerable. Whether it's trigger devices, ammunition regulation, or postal bans, the accountability of component regulation will be tested. And number 5, amicus and intervention power. DOJ's new posture could reshape how the federal government appears in state-level appeals and cert petitions, potentially tipping close decisions. Number 6, Supreme Court watch. Some of these issues, like mailing, ammunition regulation, rights restoration, may be cert-worthy. DOJ's briefs could influence whether SCOTUS accepts new cases. This realignment is bold and it's risky. Consider these potential fault lines. Uneven or arbitrary decisions. If DOJ mishandles restoration petitions or litigates inconsistently, it can face internal and external backlash. Political reversals. Obviously, this posture is vulnerable to changes in the administration. A DOJ flip-flop would severely undermine credibility. Also, the next administration in the White House could reverse these as well. State resistance. States with entrenched gun control regimes, like New Jersey, where I'm from, may seek to block or ignore DOJ's demands, leading to jurisdictional clashes. Judicial skepticism and standing challenges. Courts may question whether DOJ has standing to file pro-gun suits in local or postal cases. Criticism from civil rights or gun control groups. Opponents argue that expanding gun rights leads to increased violence or undercuts public safety regulations. Still, the momentum is real. DOJ now sees gun rights not only as something to defend, but something to cultivate. The Department of Justice is no longer content to be a bystander in America's gun rights battles. It's stepping into the court as an advocate. That change shifts entire strategic possibilities for practitioners, activists, and citizens. Keep your eyes on how DOJ handles these 925C petitions, DOJ's filings and carry delay and permit backlog cases, state-level lawsuits over ammunition laws, postal bans, and accessory regulation, and Supreme Court's decision whether to take new Second Amendment cases. I'll be tracking all of it and delivering updates. Subscribe to Martell Training Group for more videos like this. And don't forget, folks, for personal safety, concealed carry, and self-defense topics, visit and subscribe to our other channel, Defend Confidently. Stay vigilant. Your rights depend on legal clarity and relentless defense.